I used to play that's why, so it's actually easier for me. I knew the book and everything. That's why. Yeah. So baseball was like cheating softball. That's why.
Okay. Who's here? Who are we missing? Who are we missing?
I think this is everyone.
Everyone?
Yeah.
Okay.
Yeah, that's, yeah, absolutely.
Check, test. You got it? Check, test.
Ano ai ke aloha ya kākou. Thank you for joining us today. Governor Josh Green will announce a historic award to the state of Hawaii. Today you will hear from the following individuals in this order. Governor Josh Green, Attorney General Ann Lopez, and Honolulu Attorney Rick Freed. Facilitated questions and answers will follow promptly after remarks conclude. Without further ado, it is my privilege to welcome Governor Josh Green.
Thank you everyone for coming at short notice. This is something extraordinarily big. So we have a couple slides for you as well to explain what's happened. It's very positive for the state of Hawaii and our people. Hawaii has just won the largest award in its history, $916 million, as a result of pharmaceutical companies that did not properly inform doctors or patients about one of their drugs, which is called Plavix. The companies are Bristol Myers Squibb and Sanofi Adventis. Next slide, please. So here are the details, and then you're going to hear from our legal experts. So it's a $916 million award that's going to come to our state. Why did this occur? Well, there's a medication called Plavix. It's a blood thinner that people take or are prescribed when they have certain health conditions, certain heart conditions, like had a heart attack in the past, or they have atrial fibrillation, which is an irregular heartbeat. And it's a common drug that was used. However, there was a problem. Between 1998 and 2010, I believe, there was not adequate explanation that this drug was not as effective for certain communities, and they are highly represented here in our state. The drug, because Asian Americans, Pacific Islanders, and Native Hawaiians may in some cases lack an enzyme. Everyone has different biology. They may lack an enzyme. We can get into the details about that later if you really want it. They didn't then metabolize the drug adequately to work, to actually be a functional drug. So these individuals were not protected by this drug. They weren't adequately informed. There were 834,000 prescriptions or refills made to our people in Hawaii between these years of 98 to 2010, and there was no disclosure, basically, or inadequate disclosure. So many of those individuals could have been harmed when they received a drug that was not going to possibly work for them. And these are serious health problems that can lead to stroke. They can lead to death. So what happened was, in 2014, our Attorney General's office sued, and we brought the best attorneys in the state, amongst the very greatest, to come and help us with this lawsuit. And they obtained an $834 million court judgment initially. Then it went to appeal, and I'll let them talk about that. But suffice it to say, we had excellent legal counsel, and they were able to prevail. So why do we fight these things? And here's the next slide, please. We fight it's not about the money. It is about being committed to health and safety for communities. And we already have health disparities for our local people. Native Hawaiians, for instance, live 10 years shorter lives because they often don't get health care. But this adds insult to injury because they were also very likely getting a prescription for a medication that might not work for them. So we feel that companies have a duty to warn patients and doctors if a medication is not going to work properly, which is why we took up this fight. Ultimately, the court found that the pharmaceutical companies deliberately turned a blind eye on this problem to save profits. And believe me, billions and billions of dollars of profits are made on a drug like this. It was an unfair and deceptive practice, and it has no place in our state. We are going to look out for our people. So that's how I wanted to begin this press conference. We feel very strongly that this decision will hold up. We leave that to our legal teams, and I'll let them address that. But we're going to keep fighting for people, and we are very grateful for the decision today because, first of all, it's a vindication for people who have been, I guess, neglected. And then, secondly, when resources like this come in, it will enable us to invest in good public health initiatives, help people who are in hospitals, build out health care for those who may have suffered in the past and in generations going forward who will need health care that we can provide. So I think justice is being done, and I will pause there and will be available for questions.
So, to be clear, the court found that the pharmaceutical companies acted in bad faith. This is exactly the role that our consumer statute plays. It is to allow my office to go after those companies who come into the state of Hawaii knowingly choosing to act in an unfair and deceptive manner in their business practices. This case started 10 years ago, and notwithstanding the fact that it went up to the Supreme Court and went back to trial, we considered it absolutely crucial that we continue this fight. It was not about how much money we could get. It's about sending a very strong message to every business that comes to Hawaii that unfair and deceptive trade practices will be prosecuted, period. I want to introduce Rick Freed, who was the local counsel hired in 2014 to lead this case. He and his firm have done so tirelessly, again, for 10 years, and I want to thank them for all of their hard work. So, Rick.
This day has been a long time coming. We initially brought this case to then Attorney General David Louie back before 2014 when suit was filed, and Pat McTurnan and I and a brilliant team from Barron and Budd on the mainland led by Dan Albertstone have worked tirelessly on this for 10 years. As was explained in large part, this drug and our expert, who's probably the world expert on Plavix, indicated that up to a third of Pacific Islanders, Hawaiians, and Asians do not activate this drug. When you take an aspirin, it's immediately activated, but Plavix has to be activated by the liver, and specifically a particular enzyme in the liver, which is missing in those people. And of course, Hawaii is ground zero for that. And as was stated, during that 12-year period from 98 to 2010, before what is called a black box warning, and they knew this in 98 when the drug came out, that it didn't work particularly well in those ethnic groups, and they kept that secret. It took us hiring a New York firm along with the Barron and Budd firm to do word searches on 12 million, I'm not exaggerating, 12 million documents they gave to us in discovery production to find all these internal emails that went back and forth between the two drug companies, doing everything they could to hide any research on the ineffectiveness in those ethnic groups of the drug Plavix. And it isn't like this is dealing with a hangnail. If you're getting a drug that isn't effective or is only partially effective, it's going to end up with a lot of people dying. And there's no way to determine how many died in Hawaii because they were given a drug that wasn't effective for them. And so I think this verdict finally vindicates us. I'll try to very briefly say this. The award was essentially the same initially in Judge Ochiai's court way back when, and then it was appealed to the Supreme Court. But what he did is he gave summary judgment on what's called materiality. In other words, would the consumer want to know this? And the defense in our Supreme Court argued that they had all this great evidence to put on that because the first judge, Judge Ochiai, thought it was so clear that he gave summary judgment that it didn't need any more evidence, that the defense in the Supreme Court said, oh no, we got these great witnesses that are going to talk about what we had in the way of evidence. And at the second trial, which took place last October, they produced no witnesses on this subject. And so basically, Judge James Ashford spent months going through thousands of pages of documents and just filed his almost 70-page opinion today, indicating he was not at all impressed. And I will read just one small thing that the judge said, which is a study conducted by, excuse me, there's so many important points. Broadly speaking, the court, meaning Judge Ashford, finds defendants' internal emails, those are the ones that were hiding within those 12 million documents, that were authored long before this lawsuit was filed, to be far more telling and probative than much of the trial testimony offered by defendants' past and current employees. And the court found that the past and present employees had little credibility on the facts and issues most important in this case. As a broad generalization, the court was repeatedly unfavorably impressed with the avoidance and obfuscation by defendants' past and present employees' testimony at trial, and the court's findings of fact are informed to a large degree by the sentiments expressed in this paragraph. What happens after a trial before a judge is both sides file detailed findings of fact and conclusions of law, which is their view, with citations of what took place at trial. And then the judge either absorbs some of this and uses some of it, or writes his own. And in Judge Ashford's case, he spent a lot of time and came up with much of this was totally new by him. But basically, this judgment was $82 million larger than the judgment Judge Ochai gave of $834 million, and that was because they added unfair acts and practices, which the Supreme Court found and had been included in the overall judgment of Judge Ochai. Judge Ashford gave the unfairness portion $82 million, and the deceptive portion, which is the daily penalty, of $834 million. I think that basically summarizes what took place, but we'd be happy to answer any questions as best we can. And
At this time, I'd like to welcome the governor back up, and we will start with our media question and answer, and we will begin with Ashley with Hawaii Public Radio.
I'd like Pat McTurnan to come up here as well. He's lived this case forever.
So I think this is probably for governor, but can you talk about how this money is going to be spent? Is it going into the general fund, and how we're going to be able to track the spending of this? Is it like an administrator like the opioid settlement fund, or
Yeah. So that's a good question. So the question was, what will happen when the state receives this money? This money, which is very substantial, over $900 million, will, after the cost of the case, legal fees are paid, and money well spent, I would add, the monies will then go to the general fund, and it will be usable for any services. However, our commitment will be to improve our healthcare system and protect people who suffered. In other words, we'll develop a plan to put substantial amounts of resources into, for example, stroke prevention and cardiovascular treatment, augmenting public health initiatives that have been underfunded for too long. So when we get a verdict like this on this matter, we like to see a direct nexus. So we would lean very heavily on our health department. But I will say this, we have great needs, as everyone knows, in healthcare when we have tragedies, and we've suffered our share of tragedies in the past few years.
All right, mahalo. Our next question comes from Eddie with Hawaii News Now.
Governor, this has obviously been a long time coming, but is there anything the money will not be used for? I know you said you'd like to use it for healthcare, but is there anything, could it technically be used for anything, in the general fund? Legally?
We'll have our Budget and Finance Director come up, in my general understanding is that the monies would go to general funds. Yes, that's what we were talking about beforehand. We never take anything off the table. I mean, the state has significant needs as we, rebuild from disasters. I was dedicating a road this morning, which has some cost in Waikoloa, which is public safety, and it comes from our general funds. But in a case like this, we'll do all that we can to put these monies to public health needs. Not unlike, although there are certain differences, when we found tobacco to be very harmful to societies, and there was a master tobacco settlement, we devoted huge portions of that money to build out healthcare systems, prevention systems, public health programs. That would be the intent. It is a lot of money. I will say this humbly to the pharmaceutical industry: walk away from this one, because it's very clear that people were not informed about the dangers to our people, particularly those who are Asian or were Hawaiian or from the Pacific Islands. That's not okay, and I would hope that it's time to accept the decisions from two very reputable judges, and let us begin to help our people with these resources. We need to have that capacity.
Meaning warning them to not appeal again.
People are always entitled to appeal. I think our legal team has made it very clear that there was reason for the judges to make this determination, and they were careful about their decision. Also, our Supreme Court has already seen this, and if I'm not mistaken, maybe our attorneys can characterize what the Supreme Court did.
Basically, as I think I tried to explain, the main basis for the reversal was because the defense argued that they didn't get a chance to put on evidence on a part of what's called our Unfair and Deceptive Trade Act Practices statute about the deceptiveness. In other words, would an ordinary consumer have reacted had they been told about the risk? They weren't told. And so I'm sure many people would have said, if that's a risk, who knows? And also there was, during this time, a test developed which would tell you whether Plavix would activate the enzyme in your liver so as to provide the protection. As I said, we didn't ever claim that Plavix was a bad drug, just that in people that it didn't work for with life-threatening conditions, it needed to be told to them, and it wasn't.
Our next question comes from Andrew Gomes, Honolulu Star-Advertiser.
Thanks. So far, one of the defendants has so far said that they do intend to appeal, and they've characterized, similar cases in other states as having been successfully defended, and they call this outcome an outlier. How can you, rebut that? How would you, speak to appealing, and then how they characterize these other cases, similar cases in other states, and how this one's so different?
We believe they're mistaken. Two of our top judges have come up with very similar conclusions. I don't believe any other state did the work that our team did in finding all this evidence of the bad conduct that was going on between Sanofi and Bristol Myers Squibb in myriad of emails. As I read to you from the judge's opinion, this was all before any lawsuit. So this is when they didn't think anyone was watching them. So no other state went into the detail that we did. That's part of why this thing has taken a decade.
We have some more to say on this.
Yeah.
Yeah.
The cases are actually entirely different. Hawaii's case is unique. All of the cases on the mainland were basically the patients, there were personal injury actions, class actions, and so forth, claiming that there was a bleeding risk with Plavix that the patients were not told about. And virtually all of those cases were dismissed because the doctors who came and testified said, with all of these drugs, we know there's a bleeding risk. And so therefore, we would have continued to prescribe Plavix anyway. They did not involve the genetic issue here with the liver enzymes that are so important to the state's case and so important to our population.
So, and I'm going to add, these companies certainly knew that we have a very large number of Asian Americans in our population. They certainly knew that we have an enormous number of Hawaiians, and they certainly knew that there's a large number of other Pacific Islanders who are getting these drugs. A large portion of our population, therefore, unlike any other state, are affected, and they know genetically about what their drugs do, or they certainly should. About a third of our population lacks this gene to make an enzyme. It's called CYP2C19. That's the purpose of spending billions and billions of dollars in developing these drugs. It's their responsibility to know whether they work or they don't, whether they're safe or they're not. And either they were irresponsible and didn't share it adequately with a state that has so many people, or they hoped they would get away with it. Well, they didn't get away with it because we're making sure we protect our people. There's not a lot of individuals in this circumstance that live in New Hampshire, perhaps, or Maine, but in the state of Hawaii, justice is being done because of our population.
Our next question comes from Ashley with Hawaii Public Radio.
So this money is going to the state, but what about the people who took this drug and like the victims of this? Is there anything that can go to them, or are they pursuing their own legal actions?
The difficult part of that is that it's sort of a belief drug, and unless you're tested, there's no way to prove, though the testimony of the experts were that certainly many people must have died as a result of taking this drug when they couldn't activate it in their liver enzyme. But there's no way to prove that Joe Smith or Mrs. Hayakawa were the ones that were affected. And so that's why it's brought by the state, and the statute is specifically for the estate. It's HRS 480.
So what we would hope to do, as I mentioned kind of a little bit, is to take some of these resources and support stroke clinics, to support heart clinics, to support extra testing for individuals that have needs. And so we have an opportunity as the state to provide global public health for our people. And we also want to set an example that we want the pharmaceutical industry to be thoughtful about different ethnicities. And that has been a problem for many decades. Research wasn't done on women, for example. And that had to change once people realized that men and women, in many cases, will metabolize drugs differently or respond differently. And that's now obviously part of the science, that other ethnicities with subtle genetic differences should be honored. And so we're trying to make that major point here.
Governor, our final question comes from Eddie, Hawaii News Now.
Just want to ask Governor personally, what was your reaction when you heard the ruling today?
I was pumped because I love it when our team gets justice for people. I've heard over the many decades that it costs a lot to bring drugs to market, and there are justifications for drugs being very costly. Well, that is the case, and lots of research has to be done. But that justification has to be reflected then on what's safe, what works. And if something wasn't safe and it didn't work, then all those other arguments go out the window. So it's very important. It's very important that we insist on the integrity of the science so that we actually care for people well. But if you want to know just my general response, I was very excited to imagine that there will be extra resources for us to provide extra health care for our people in the state of Hawaii after a very tough period of COVID and the wildfire. I'm excited about having some resources to help people.
One follow-up, and if you can't answer this, that's fine, but if appealed, could it be years before the state gets that money? And you said legal day, what could that takeaway money be, not the whole 916?
You want me to give a first go again?
Sure.
Yeah. So actually, our attorneys took a much lower fee because they believed in this case, which was very good. So we'll get 80% or so, maybe even more, ultimately based on growth and interest and so on, which is great. And this thing was a 10-year trial, so they were doing that work. So we're grateful for that. That's one piece. Also, we expect that if the appeal occurs, we probably will encourage it to go quickly and perhaps right to the Supreme Court.
The first case did go to the Supreme Court because of the substantive nature of the case and the uniqueness, and we're hopeful that when we ask the Supreme Court again to take the case directly, if they appeal, and we hope they don't, but certainly they have that right, that they will take it directly. And it's so hard to say, but if I had to estimate it, I would hope maybe within a year or so, if they appeal, we would get resolution. In the meantime, the statute provides 10% interest, so that's another $90 million in the meantime if it were to go about a year.
Yes. Okay. So again, to sum up, this is the largest award in the history of the state of Hawaii. It validates the work that was done on behalf of patients, and let's be quite direct. People knew that this medication wasn't going to work on Asians and Hawaiians and other people from our region, yet we weren't told, and lots of people suffered. So we will hope to right that wrong, and we will be supportive of people with our public health system with these dollars. So we're grateful to everyone. We're looking forward to working with anyone when they're in these industries, but they have to be direct and honest with us, and that'll be our standard. So thank you, guys. Over.
Governor, this formally concludes today's news conference. Mahalo.